Today's session is both timely and urgent. Across our region, many forced displacement experiences are shaped by gender norms, gender harms, yet gender-based violence is still too often treated as private, as domestic, secondary, rather than a serious protection issue with clear grounding in refugee law and human rights obligations. That's why this training becomes very, very important for us. And as we begin, it is also useful to recall that everyone has the right to seek and enjoy asylum from persecution, and that refugee recognition must be regarded as a peaceful and humanitarian act extended as part of human rights. So looking at this, our objective is practical. How do we strengthen gender-based asylum claims from interviews to legal framing to evidence to final decision making so that protection outcomes are lawful, credible, as well as survivor-centered?
So I'm just going to do an overview of the legal environment and the context for GBV persecution-related claims in East Africa, looking at these particular countries, because we will have fuller presentations on Uganda and Kenya. I won't focus too much on those particular countries. So, and just to say, I'm joining you from Johannesburg today. So, GBV as a ground for claiming asylum. Gender-based violence remains pervasive societal issue influenced by various factors, including patriarchal structures, gender disparities, cultural norms, as well as a lack of awareness. Despite its severity as a human rights violation, the 1951 Refugee Convention does not explicitly address GBV as a protected ground. However, UNHCR's guidelines recognize GBV as a distinct form of persecution and calls for gender-sensitive approaches to refugee status determination. I've just pasted the UNHCR guidelines here for you, so you can refer to them if you would like to. And then to look at the detail of those guidelines, specifically on the term gender-related persecution, even though gender is not specifically referenced in the refugee definition in the convention, it is widely accepted that it can influence, dictate the type of persecution or harm suffered and the reasons for this treatment. The refugee definition, if properly interpreted, covers gender-related claims, and there is no need to add an additional ground to the 1951 Convention definition because it is covered. I also refer to the CEDAW General Recommendation 19. CEDAW is the Convention for the Elimination of Discrimination Against Women. It is a useful recommendation for our context, even though it does not specifically refer to asylum and persecution and GBV-related persecution. The definition of discrimination or gender-based violence is a form of discrimination that seriously inhibits women's ability to enjoy rights and freedoms on a basis of equality with men. It is useful for us to have this international law support within the definition or the broader context of violence against women so that it can support us when we are enunciating and supporting claims of GBV within the context that we're speaking about. Looking specifically at our current context and understanding what it is that we're dealing with, there are, and this is claims for asylum from persons from the DRC, persons fleeing conflict and violence from North Kivu, South Kivu, and Ituri may meet the criteria for refugee status under the 51 Convention. UNHCR considers people fleeing from armed conflicts in these three particular provinces and adjacent areas to be in need of international protection under all of these protection criteria and mandates. So the Convention, the Cartagena Declaration, complementary forms, in addition to the OAU 1969 Convention, which is relevant for our context in East Africa. The contextual situation in this eastern part of the DRC, all parties are reported to have committed and being involved in human rights violations, and a range of human rights violations, including widespread sexual violence. The particular context in the DRC, in response to these M23 rebels, the government has relied on local militia and armed groups, which are termed Wazalendo, many of whom have been accused of committing human rights violations. There are multiple armed groups in this region that have aligned themselves with the M23, either openly or in secret. I've just put a map here so you can see the context that we're looking at. You can see the eastern part of the DRC and how close it is to the countries that we're speaking of, particularly Rwanda, Uganda, and not as close to Kenya, but we are seeing claims from the eastern part of the DRC in Kenya. Moving on to refugee protection in Uganda. Uganda hosts the largest numbers of refugees in Africa, with over 1.9 million refugees and asylum seekers. They operate a progressive open door policy, granting refugees rights to work, move freely, and access public services. Uganda uses a prima facie recognition for mass influxes and individual assessments for others. Looking at GBV asylum claims in Uganda, GBV falls under membership of a particular social group or under sex or gender. Asylum seekers fleeing violence, including rape, forced marriage, intimate partner violence, are considered for refugee status by the Refugee Eligibility Committee. Survivors face a range of barriers, which I'm sure you'll hear more about in the next presentations. UNHCR and its implementing partners provide services including psychosocial support, medical assistance, and so forth. I won't speak a great deal more about this. Moving on to refugee protection in Rwanda, the majority of Congolese and Burundian refugees in Rwanda were registered on a prima facie basis. Since August 2021, all new asylum seekers, regardless of their country of origin, must present their asylum claims and go through an RSD process carried out by the government of Uganda. Women and children make up more than 75% of the refugee population. There is a very high rejection rate for asylum seekers from outside the region. And there is no way to lodge complaints about the RSD process. So if your case is rejected, there's unfair delays, processing, and so forth. It's very difficult to try and deal with that after the fact. Looking at GBV asylum claims in Rwanda, there isn't what we see as a right of representation within the RSD process. Lawyers do support and give legal counseling on the process. If, however, a claim is rejected, the lawyer can assist with the appeal, but no reasons are provided for a rejection. So supporting an individual with a claim, with an appeal case is very challenging. Rwanda uses one-stop centers in all districts to provide a multidisciplinary approach for SGBV prevention and response. There is specific focus on supporting survivors, and UNHCR works with its various partners to raise awareness of sexual and gender-based violence. Risks. These are risks that have emerged out of the UK-Rwanda Asylum Partnership, which I'm sure you all are aware of. I won't go into the background of that, but the UK passed the Safety of Rwanda Act in 2024 to facilitate the removal of asylum seekers to Rwanda. These asylum seekers who are seeking asylum in the UK. The policy faced significant legal challenges, and no such removals took place under the original plan before this law was enacted. The UK Supreme Court ruled that the plan was unlawful due to the risks of refoulement. So, learning from this process, we see that there are certain concerns and challenges about applying for asylum in Rwanda, and in particular for applying for GBV claims, where you might not receive the kind of protection which is required. Moving on to Kenya. Kenya is a major host country for just under 1 million refugees and asylum seekers, and a significant number of these individuals are survivors of GBV. The Refugees Act governs refugee management, and there is a shift towards the Shirika plan, which focuses on integrating refugees into local communities rather than housing them in those very large refugee camps. Looking at intersectionality, women with disabilities, single mothers, or those with diverse GSC face increased risks and limited access to services. GBV claims for asylum in Kenya, there are ongoing efforts to include GBV as a specific recognized protected ground within the Kenyan RSD process. And for highly vulnerable individuals, including those with severe GBV claims, resettlement is a key, though often very slow solution. Moving on to Burundi. Burundi is a signatory of the UN Geneva Convention, as well as to the African Union Convention on Refugees. They have a national law which guides the protection of refugees. Burundi hosts not a huge number compared to Uganda and Kenya, but a smaller number, but still a sizable number, and mostly with asylum seekers and refugees coming from the DRC. Looking at GBV claims in Burundi, Burundi is managing a significant influx of refugees fleeing violence in the eastern part of the DRC, with a very large percentage of these being women, and women and children who have or are experiencing severe GBV. UNHCR is working to strengthen the capacity of the asylum system to ensure consistent access to quality, gender-sensitive asylum procedures, while the specific legal and individual asylum claims on GBV are usually confidential. So we don't know how many claims or which people are applying on this ground. International organizations operating in Burundi are working to ensure that victims of sexual violence are identified and provided with access to protection and various other services as is required for their particular persecution. And then moving on to Tanzania. Tanzania operates a very strict encampment-based asylum system governed by the Refugees Act. The system restricts movement and employment. The refugee status determination procedure is led by the government, by the National Eligibility Committee. And the system focuses on temporary protection, and as well as services such as repatriation or third country resettlement, rather than local integration. GBV claims in Tanzania, while the Refugees Act provides the framework for protection, the Eligibility Committee is responsible for determining refugee status. This committee has faced numerous challenges in how it functions on a day-to-day basis, and this has left and is leaving many asylum seekers in a situation of limbo where they're not receiving adequate protection. While there is a lot of data about GBV protections being made available to refugees once they are in Tanzania and experience GBV in Tanzania, but there's little data on whether this particular ground is being used successfully to grant asylum. And I've come to the end of that. Thank you very much.
Greetings from Kampala, Uganda. I'm joining you from the Pearl of Africa. So I'll be looking at gender claims, asylum claims from the Ugandan perspective. In Uganda, we are signatories of the 1951 Refugee Convention and the OAU 1969 Convention. And most of when an individual is claiming asylum in Uganda, they are recognized under the OAU Convention by and large. We only apply the 1951 Refugee Convention when a refugee is being considered for resettlement to a third country. So under the 1951 Convention, the definition is more individual in nature. But when it comes to the 69 Convention, it broadened the definition of a refugee and included external aggression, occupation, foreign domination, or events seriously disturbing public order. The reason why the 69 Convention came into play was at that time, very many African nations were going through civil strife and fighting for independence, and many large numbers of people needed protection, but then the 1951 Refugee Convention was narrow and didn't really fit the circumstances and context of Africa. So that is why the 1969 Convention was signed up by the different nations. What I want to say, in Uganda, we have the 2006 Refugee Act, and we'll adopt both the 1951 Convention definition of a refugee, meaning that you flee because of fear of nationality, race, membership of a particular social group. But then also when there is a large-scale disturbance and when there is an influx of refugees, the minister is allowed to recognize refugees on a prima facie basis, meaning that they do not have to go through individual interviews. And usually, refugees are recognized according to where they're coming from. Right now in Uganda, the two nationalities that are granted prima facie status are refugees fleeing DRC, Eastern Congo, and also refugees from South Sudan. But if you're a refugee coming from Somalia, from Eritrea, Ethiopia, then you will go through a process, what we call a refugee eligibility committee. And that's where a gender claim can be considered. So under Article 1, 2 of the 51 Convention, specifically says that an individual will be recognized because they have fled because of their race, religion, nationality, political opinion, or membership of a particular social group. So gender claims sometimes intersect with some of these reasons, meaning that if a woman is raped because of her race or nationality or religion, she can also claim for refugee status under any of these grounds. But mostly membership of a particular social group is a ground that we use for gender claims. And then when it comes to internally displaced persons, they cannot be considered for refugee status because they've experienced violence within their country. But when they cross the international border, then they will be considered under the 69 Convention. Please go to the next slide. So the gender claims under the 1951 Convention can be considered under female genital mutilation, and also forced marriage or child marriage, and then domestic violence where the state is unwilling or unable to protect, and then where there is sexual violence like using rape as a weapon of conflict. For mostly refugees fleeing from the Democratic Republic of Congo, women have been recognized as refugees because of sexual violence in conflict settings. And then also, for gender claims, you can be recognized under persecution on sexual orientation or gender identity, but this does not apply to Uganda because we have a law both under our penal code, and also we have an anti-homosexuality act that does not recognize persons with sexual minorities in Uganda. So you cannot flee to Uganda and claim asylum on a gender identity using sexual orientation. And then honor crimes also can be under refugee convention, but then we don't have this in Uganda, but we do have some Pakistanis who have fled to Uganda. And if we have Pakistanis who have fled on religious grounds, so if in the course of their interview, they also say that they are facing persecution because of honor crimes in their country, it can be considered by the Refugee Eligibility Committee. And then for sterilization or reproductive control, but this doesn't really apply in Uganda. I was just giving examples of gender claims that can be brought under the 51 Convention. Please go to the next slide. Under the 69 OAU Convention, it broadens protection and covers generalized violence that happens to a country going through conflict. It expanded on the refugee definition. So in addition to the 1951 grounds, that is the membership of a particular social group, the OAU Convention also includes persons fleeing due to external aggression, occupation, foreign domination, or events seriously disturbing public order. And we've seen this a lot when it comes to refugees. Like, let me give an example. Usually this happens after election cycles. So in 2015, after the South Sudan elections, there was a lot of events seriously disturbing public order. And then we saw 1 million South Sudanese refugees crossing into Uganda in 6 months in 2015, between June 2015 and December 2015. And among the people who fled were women who had experienced sexual violence, either by the soldiers, government soldiers or militia. So these women were recognized and granted refugee status in Uganda. Please go to the next slide. So for gender persecution, it may arise from armed conflict and mass displacement, like in the Eastern DRC, particularly in the Kivus, in North Kivu and South Kivu. The region has been experiencing armed conflict for the past 25 years. And every year, Uganda receives refugees from Eastern Congo, and it's mostly from armed conflict. And then also breakdown of social and legal protection systems. So most of the time, women cannot claim protection within their country, and then they will cross the border. And then systemic sexual violence. So for gender claims, I have to say that both in Uganda, we have got information of men and women suffering sexual violence. But most of the time, for gender claims, it's women who can relate their story and be granted status under sexual violence and gender claims. But for men, I don't know of any case of where a man has claimed asylum on gender violence grounds, but we've had cases of where men are used that rape is used as a weapon of war when there's armed conflict in Eastern DRC. And then any harmful traditional practices exacerbated by conflict, that is why women will come into the country. But most of the time, women and girls fleeing face widespread sexual violence, and this is during conflict when they are fleeing in order to access safe passage to the neighboring country. Women and girls face a lot of sexual violence, and also you may find many women actually end up conceiving and having children born out of conflict. Please go to the next slide. So those were broadly the grounds under which Uganda would recognize women under gender claims under the 51 Convention and 69 OAU Convention. But then there is also exclusion under the 1951 Convention. Not everyone will come into the country and claim asylum because unfortunately, when there is a conflict, you have mixed migration. You don't know whether there are some armed elements among the people who have fled in the population. I think in Uganda, we had a very big challenge where we had M23 militia getting into the country. So, and that is why in Uganda, when you come into the country, the screening is done actually by the security forces. So you'll find that the police is heavily involved and the army is involved in when it comes to screening of refugees. Let's go to the next slide. So under the Article 1F of the Refugee Convention, 1951 Convention, some individuals are excluded from refugee status if you can prove that they have committed a crime against peace, a war crime, a crime against humanity as defined in the international instruments drawn up to make provision in respect of those crimes, or if the person has committed a serious non-political crime outside the country of refuge prior to their admission to that country as a refugee, and also if a person has been guilty of acts contrary to the purposes and principles of the United Nations. Please go to the next slide, where I'll give specific examples. So examples of excluded individuals are military commanders guilty of war crimes. So even if they have gender claims and they are survivors of sexual violence, once it is proved that they are guilty of war crimes, these individuals will be excluded from being granted refugee status. And then also it can include wives or partners of military commanders. They may be denied refugee status. And then military commanders, you have to look at the command responsibility. They would be excluded from claiming asylum. And then members of armed organizations or militia. And then also another example is if a person is found guilty of a serious non-political crime. An example of a serious crime is murder, like if conflict happened in your country and then you are convicted and you are serving time in prison. So you are serving that you had committed murder, rape, arson, survival, sex work, and armed robbery. If it is proved that you were having these crimes, then these offenses are deemed as serious and you may be excluded from getting asylum. So even if you have a legitimate gender claim, please proceed to the next. Okay, sorry, I've come to the end of the presentation. But what I wanted to emphasize, let's just go to the previous slide. But what I wanted to emphasize is that in Uganda, we have had cases of women who have assisted soldiers and who have been, I would say, abducted and then kept as sex slaves, staying with the military commanders. But when they come to Uganda to claim asylum, they have been denied refugees status. And that is because it's deemed that they provided support to the military commanders, and then they are excluded under Article 1F of the 1951 Refugee Convention. So thank you so much for this presentation. I'll be able to chip in and I look forward to the group discussion. Thank you.
Now we can take a deep dive into seeking asylum on the basis of GBV in Kenya. And as I begin my presentation, I want to acknowledge the great insight from one of our members, Rachel Wahome. I hope she's on this call, from Refugee, who offered great perspective and insights on how GBV is processed, how GBV claims are processed in Kenya. So from a legal standpoint, it is important to state clearly that GBV-based claims are legally admissible within Kenya's asylum framework, and there's no legal prohibition in principle against advancing these claims. All the forms of GBV that my colleagues Devota and Kaajal have spoken to before are legally recognized and admissible in Kenya. And this is through a broad legal framework that recognizes all the forms of gender-based violence across criminal, civil, and constitutional law. So under the criminal law, we have various statutes criminalizing gender-based violence, including the Sexual Offences Act, the Prohibition of FGM Act, the Penal Code, and an Anti-FGM Act, and just a range of many others. You can also bring a civil claim under the Protection Against Domestic Violence Act. That's to seek a restraining order and ways to protect persons undergoing gender-based violence within the domestic setup. And we also have claims that could be brought under the constitutional law that's enforcing your right to equality and non-discrimination, because we understand that GBV or violence against women is a form of discrimination against them. Any other person on the basis of their gender, really. However, relevant to refugees, the Refugee Act 2021 in Kenya incorporates the international refugee definition directly, and that means that GBV claims can fit squarely within the refugee determination process. And I must say at this point that is also a signatory to the 1951 and 1969 refugee conventions that my colleague Devota deeply shared about. And so we are well aligned on that. And I must say that the core challenge is therefore not the absence of law, but how the law is interpreted and applied in practice within the asylum system. Next slide, please. So under the Refugees Act, the Department of Refugee Services in Kenya is responsible for the operational aspects of protection and assistance. I'm on the next slide. And this includes refugee status determination, sorry. And so in theory, this places GBV claims firmly within a structured legal and administrative process. In practice, however, the criminal justice system operates largely in parallel to the refugee services that are provided in Kenya. And so one is required to report GBV to police, and that does not automatically inform asylum procedures, and the failure to report is often misunderstood or held against the applicant. We already know the common challenges in reporting GBV, where delayed reporting is criminalized, lack of reporting, and those other challenges that face survivors of GBV. And then now there's a heightened challenge for refugees. And this, the disconnect now between our criminal justice system and the refugee services becomes critical when credibility and protections assessments are being made without sufficient regard to the barriers that survivors face in accessing criminal justice mechanisms. So in terms of making, just trying to see, we're on slide 11, I believe. In terms of making a GBV claim under the Refugees Act, and GBV claims may arise at several points in the asylum process. There are procedural barriers and substantive barriers to accessing these claims. And in terms of the procedural barriers, survivors face significant hurdles. As I discussed, late or partial disclosure is common due to trauma. We know how trauma makes survivors forget some aspects of the GBV they have undergone. And if they report this at a later date, it is either termed as lying or a made up story just to be able to access. For example, in Kenya, it is commonly said that they make up these stories in order to access external resettlement. And of course, there's also fear, stigma, and safety concerns, and these are frequently treated as a credibility problem. And inconsistent narration is also common, but you find that the officers assessing these claims do not have sufficient training on trauma-informed assessments, and such inconsistencies can be read as dishonesty rather than reading harm into them. And there's also a big challenge around documentation. So many survivors will lack medical reports or police records where they are reporting, and this exposes them to further risk. In terms of documentation in Kenya, refugees also face a myriad of problems with regard to documentation. They might be hesitant to report because their status in Kenya has not been fully determined as a refugee, and they're an asylum seeker at that point, and therefore they may be hesitant to report to the police just because they don't have the right documentation and have faced harassment in the past due to that lack of documentation. And we are also moving towards the Shirika plan that's geared towards integration. However, at this point, Kenya has previously strictly had an encampment policy, and to move from one camp to the urban area, you will need a movement pass. And therefore, if a person or a woman has fled on the basis of GBV and has moved from the camp area, which is their designated place, and moved to another area, they would be unable to report, essentially because their movement was illegal. And I want to move to assessing the intersectional barriers of blame and shame and bias. Failures in GBV claims are often compounded by intersectional barriers, and GBV intersects, for refugees, gender intersects with poverty, economic dependence, culture issues, social norms, displacement status, and in ways that shape how these claims are assessed. And victim blaming is quite pervasive, especially in Kenya, and is often intensified for asylum seekers, with their credibility undermined by perceived non-compliance or deviation from expected behavior. So with the refugee communities in Kenya, we also find that GBV is still considered very private, a private act, and therefore they do not easily want to disclose these challenges. And so moving to the practitioner's role in assessing in GBV claims and strengthening, what can practitioners do to make protection possible? And practitioners play a decisive role in shaping the outcomes of clients, and they can do this procedurally by preparing clients and officers for face disclosure. They should also help to document trauma impacts on memory and narration, which is purposeful in mental health support. And I have seen organizations that offer mental health support, which is a very integral services to refugee protection. However, the notes from the mental health support and psychosocial support should be kept as part of should and can be kept and used as part of the evidence to assess claims, and of course, respecting confidentiality processes. And it is also the role of practitioners to advocate for gender-sensitive interviewing, to support asylum seekers with reporting GBV, because they understand that the challenges the asylum seekers are facing and the barriers to reporting, and therefore being a service provider who helps them navigate through these challenges would then contribute to the success of the claim. And most importantly, we must, as practitioners, center survivor dignity and agency. How we go about this could be by training the practitioners who are helping to bring these claims. And in terms of the substantive ways we could approach this is to frame GBV as a systemic issue and not isolated or particular to one refugee who is presenting the GBV issue as at that point, because we know that gender-based violence, one, disproportionately affects women, but could be targeted to a person because of their gender or other intersecting levels of the person. And therefore, it is not an isolated case that this person underwent GBV just as an individual. It is systemic, and we need to also evidence barriers to protection, not just the existence of laws. And in terms of the many failures we are seeing on GBV claims, for example, even at the appeal stage, and where their claims are rejected, and there is no reason that's articulated for that, I think we should be moving to a point where we are challenging these failures through administrative and judicial processes. Last slide. I wanted to also focus on how we could expand the narrow particular social group definitions in GBV claims that then impair how these claims are assessed. And for practitioners, we should not shy off from using gender confidently as a starting point, and we define it by its status and not harm, and ground the group in the particular social context. So, for example, how women are treated in their particular society, whether it's that particular refugee society that the person is coming from, culture, religious context, norms and patterns of tolerance and indifference to GBV. And also to note that gender is an immutable characteristic. And so just because immutable characteristic is so broad does not invalidate a particular social group where persecution targets women as women, or for example, rape is used as a weapon of war. And let's continue to use laws and enforcement gaps, expert reports, and NGO data to demonstrate how society perceives and marginalizes a particular group because of their gender, and also to reframe gender-based violence as structural and not a private harm, and also center the lived experience of the particular person who is making the GBV claim. So I am quite passionate about state obligations. And so with this particular issue, we must emphasize of gender-based violence claims, we must emphasize patterns of state knowledge, tolerance, and failure to protect or counter private harm as a reasoning when we are contesting these GBV claims, or when refugees and asylum seekers have been denied protection on the basis of GBV. And it is also up to us as practitioners to help explain delayed disclosure, inconsistency, and survival strategies. I'll stop here for now.